Hey everyone. So let's jump right into this one. We're continuing on in our bad series, and this is an attorney who may have done something bad because he is having to justify his actions to the Florida 6th District Court of Appeals, who are questioning his reasoning for filing this action. His complaint was kind of questioned as frivolous and meritless, and he's having to justify a good part of it and not doing a very good job of it during this hearing. He doesn't seem like he's very well prepared. Since this is the appeals court, they don't really go over what the basis of the initial lawsuit is. So let me give you the groundwork. So this takes place in Orange County, Florida. You may be familiar with Orange County. They are very well known for their oranges being next to, Disney World. There's a suitcase thing. Yeah. All that stuff. Universal Studios, it all happens in Orange County. Center of Florida. Fun stuff. This is Mr. Jerome Ramsarin. He is the attorney for Foreman Electric Services. Foreman Electric Services is a power electrical contractor. So when there's damage to the power grid, they come in and help repair it. So say this woman hadn't gotten down when she should have, they could have come in and helped repair the damage from, her ridiculously stupid antics. Now, Foreman was working in Puerto Rico after the series of hurricanes just absolutely devastated the island a couple years ago. They were working under LSQ, who was the higher up contractor. They were a subcontractor. I believe they were a subcontractor, but they'll get into that. In the Orange County District Court, Foreman filed an action against LSQ funding. Before that action was ruled on, they amended that petition and filed a second one. That was ruled on, and it was dismissed with prejudice. Foreman appealed that, and they asked for leave to file a third amended complaint. The appeals court denied that, and in turn ordered Foreman and its attorney to file a brief showing cause on why the initial petition and the amended petition and all of them were not frivolous or meritless. They had 10 days. I wonder if that's business days or calendar days. I have to look that up. 21 days later, that's not 10, that's 21 days later, they filed the required documents. That's more than twice as long, twice plus one if I mathed right. Pretty sure I did. My brain's working today. So LSQ moved for attorney's fees and costs against the appellate, but they didn't move for sanctions against the attorney personally. So the Court of Appeals, on its own, sua sponte is the Latin term for of one's own accord, meaning on their own, without being prompted. Generally, for a court to take action, somebody has to file something. They have to trigger it. They got to push the button. They got to say go. And sua sponte, in this case, what they're saying is the court filed this on their own without being asked to. They ordered counsel, which was the appellant, Mr. Ramsarin, to show cause why sanctions, including attorney's fees and cost, incurred in defending this appeal should not be imposed against him. Because if you're going to file something that is deemed frivolous and meritless, why should the other side have to pay? They scheduled a show cause hearing, which is what we're about to watch, on why sanctions should not be opposed against him individually, not the company, but him individually.
All right, I think that we have everyone now from the waiting room. Good morning to everyone. We are here for a special session of the 6th District Court of Appeal. in case number 6D232601, Foreman Electric Services, Inc. versus LSQ Funding Group, LC. At the outset, it does look like we have more people than we're required to be here. So I'll just ask everyone who is not Mr. Ramsaran to go ahead and introduce yourselves.
Good morning, Kevin Fowler for LSQ Funding Group LC.
All right, good morning, ma'am.
Good morning. I am a stenographer with Veritex Court Reporting.
Okay, and just so everyone knows, we are being live streamed on YouTube this morning. I don't know who hired a court reporter.
That was my office, Your Honor.
Okay, are you aware, sir, that we are being live streamed this morning?
I was not, but that's fine.
Okay, do you wish to keep your court reporter here?
I've never dealt with live streaming. If it's all the same to the court, I would like to have the court reporter tag along.
Okay. Ma'am, if you'll just stay muted throughout the proceedings, I'll go ahead and allow that this morning. My name is Petra Brownlee. I'm going to be the presiding judge this morning. I'm joined today by my two colleagues, the Honorable Keith White and the Honorable Joshua Mize. We are here today on an order to show cause as to why sanctions, including attorney's fees and costs incurred by the appellee, should not be imposed against counsel Jerome Ramsaran personally, pursuant to both Florida Rule of Appellate Procedure 9.410A, as well as Section 57105 1B of the Florida statutes. Sir, am I pronouncing your name correctly?
You are, Your Honor.
Okay.
Yes,
All right.
Ramsaran.
Ramsaran. Okay, thank you for that. Let's see. So I will note at the outset that the appellant, Foreman Electric Services, Inc., previously filed a response to our show cause order, and we received that back in June. On Friday, we received both an amended response as well as a verified response from counsel. We have reviewed all of those documents. It's my understanding, sir, that through those documents, you wish to inform us that that original response that we believed, frankly, pursuant to language in the response, that it was filed solely on behalf of your client, was actually filed on behalf of both of you. So, and I will allow you to flesh this out for us a little bit further, and I'll certainly allow you to tell us anything that you would like in response to our show cause order. But before we get to that, what I intend to do is to have me and my colleagues ask you some preliminary questions to sort of frame this so that, we have sufficient background here. All right, so sir, what I'd like to start with is, could you please tell us how long you have been practicing law?
This month makes my 10th year in practice.
What area of the law do you primarily practice?
I primarily practice what I would like to call consumer protection mostly. So we do, well, I'll break that down. We do a lot of homeowners insurance claims here in the state of Florida. We do personal injury, actions against banks, lender institutions on behalf of consumers. We have in the last year or two begun working with more in the commercial space in the realm of government contracting. We've been dabbling here and there, thus our involvement in this case.
Okay. And how many appeals throughout that practice have you handled?
Maybe more than 10, less than 20.
More than 10 appeals.
More than 10.
And for how long? How many years have you been practicing appellate law?
I've probably been engaged in the appellate circuit. I mean, as far as filing appeals, I don't want to say anything incorrect, but I believe at least for the last 5 years, if not more.
And are you handling these appeals by yourself, or is there anyone who's assisting you?
At the time of this case, there was someone assisting me. A longtime paralegal and former attorney named Tracy Long.
Okay. But you're primary on your appellate cases, is that correct?
Correct.
Okay. And sir, have you reviewed all of the Florida rules of appellate procedure?
I'm fairly familiar with them. I won't say I know them all inside and out, but I mean, I know how to, use my resources as needed and to try to comply with the rules as necessary.
Okay, so what I want to do is start with the contents of your initial brief, because pursuant to our show cause order, there are two bases for fees, one of which is Rule 9.410A, which is the sanctions rule under the Florida Rule of Appellate Procedure that provides that the court on its own motion may impose sanctions for any violation of these rules or for filing any preceding motion, brief, or other document that is frivolous or in bad faith. So I want to get to the briefing portion of that rule. And I believe that this was raised by the appellee in their previous motion for sanctions under 57105. When I look to the argument portion of your initial brief, what I find are a plethora of citations to sort of, I want to say boilerplate or well-settled rules of law that I don't believe either party contends aren't applicable here. But that's just a sort of broad rule. There's no argument with regard to any of those citations. And so can you tell me about that and why there is no analysis in the argument section of the brief? And I'll tell you why I'm asking you that is because under Rule 9.210B5 of the Florida Rules of Appellate Procedure, that rule requires an argument with regard to each issue that you intend to raise on appeal.
If I may I pull up the initial brief?
Yes.
I wasn't aware we'd be talking about it today. Give me a moment. Let me grab that. Are you talking about the initial or the amended?
The amended initial brief.
Understood. Okay. So as I go through the brief, I know we have our statement of facts, and we I'm looking for the section that you're specifically referring to.
I'll tell you why I'm saying this too, counsel. In addition to the rules, it strikes me that the appellee argued in their motion, which isn't before us today, but it's the same reaction, frankly, that I had when reviewing the brief is how would the appellee know what arguments to respond to if you were simply setting forth well-settled points of law?
I see, Your Honor, and I do believe we do flesh this out a little better in probably our responses to their motions for sanctions. But I do note that even within this, that we do take the position that, let's see, let me make sure I'm saying this correctly, that this is not law I'm looking at. I'm looking at this quickly, so bear with me.
Counsel, I'm a little surprised that you say you didn't understand we'd be discussing your brief today when the order to show cause specifically said the hearing was about your brief.
Respectfully, Your Honor, I thought that the hearing was with regard to the fact that I did not provide a response to the June 18th show cause order.
The order to show cause says why sanctions should not be imposed against him pursuant to Florida Rule of Appellate Procedure 9.41A for, quote, filing a brief that was frivolous or in bad faith.
I thought it was for failing to respond to your order to show cause to that exact issue. Maybe I misunderstood. But with that being said, I do believe we take the position within the brief that there is an issue of fact created in these documents that we presented to the lower tribunal here. Specifically, the fact that that this case arises from a standard subcontract agreement, essentially, between our client and a third party named Haleron. Haleron ultimately sold its invoices or line items to another company, well, LSQ in this instance. And LSQ ultimately, we take the position that by virtue of that invoice purchase agreement and the language within that, and a subsequent action that LSQ, in which Haleron sued LSQ, and wherein LSQ answered pursuant to its answers and affirmative defenses, that there is a cognizable and judicial issue of fact in this case over whether or not we are a third party beneficiary to their invoice purchase agreement.
Counsel, can you tell me two things? Number one,
Yes.
is that the answer and affirmative defense is filed in the other action in our record on appeal?
Yes, Your Honor, it was
Okay.
made a part of the record on appeal. Well, maybe not part of the record on appeal, but via the appendix.
Why is that proper under the rule?
Well, I don't want to say again, Your Honor, I'm not certain. I believe it could be part of the record on appeal because it was part of our third amended, our motion for leave to file a third amended complaint, in which a lot of those allegations were put forth. But I do know for certain that they were put into the appendix.
But would you agree with me? Is there some rule of appellate procedure in your mind that would allow you to insert items into an appendix to an amended initial brief that were not included in the record on appeal?
Not that I know of, Your Honor, but I believe these were put into the record on appeal, or at least in the lower tribunal.
That's what I'm trying to get clarification on,
I
counsel,
see.
because
The only reason we would not, or we would file the appendix in a case like that, frankly, is if we put it into the record and the record on appeal didn't produce those items afterwards, which could have been the case as well. Meaning that those items were not made part of the record, although they were filed in the lower tribunal.
Oh, okay, well, would you agree with me that the rules of procedure in the appellate court require you to have documents that you're going to cite for purposes of the appeal in the record on appeal, not just filed in the lower tribunal? We don't have that before us. I guess this brings me back to the original point, which is if maybe there is something that would support an argument that you're now making about third-party beneficiaries. And I am wondering what is happening with the argument section of this brief such that this is raised in here and such that the appellee would have notice that that is your argument, that you're relying on the answer and affirmative defenses raised in the other action. And can you show me in this brief where the appellee would be put on notice of that and not simply, I mean, I know that that was a part of your argument in response to the show cause order. That's separate in my mind because that's
Understood.
far later.
Understood. Paragraphs 8, 9, 10, 11
What document?
of the amended initial brief. 8, 9, 10, 11, 12.
What page are you on, counsel?
4, 3 and 4.
Okay, sorry. This is just about the argument section.
I see.
Counsel, you seem there's two different issues here, and I think we're trying to get you to address one and you're addressing the other. So there's the merits of your claim and whether or not you all had an argument you could have made that wasn't frivolous. Okay. Then separate from the merits, there's you complying with your obligations as appellant's counsel to put those arguments into a brief. So before we get to the kind of merits of whether or not you could have had a claim, right, and whether or not the trial court did in fact err, you had some basis to dispute that, I think the issue is you wholly failed to articulate an argument in your brief, even assuming you had one. There's just no argument at all. The argument section that you have labeled argument is just kind of a cut and paste from various rules and cases with no explanation whatsoever how any of those authorities, make an argument, why the trial court would have erred according to those authorities. There was just no serious attempt to meet your appellate burden. So it's not really the merits of your claim we're at this point, although I looked at them and it does seem the claims were frivolous. At least it's hard to completely evaluate what argument. Just looking at the record, it's very hard to see how you could have made a meritorious argument. But we're not even there yet because we're just talking about the contents of your brief and the complete failure to include an argument section and to comply with Rule 9.210 requiring you to set forth arguments on each point of appeal. You had 2 points of appeal. There was no argument section. There was nothing in your argument section to support or put forth an argument on those 2 points of appeal. Do you see the distinction I'm making?
I do, Your Honor. I see it's more I guess, substantive as to what's in the brief itself. Let me see.
And I'll tell you, I did, in terms of the order to show cause, I did just look again, and you had the order to show cause explicitly said this was about your brief, and the hearing order that we entered setting this hearing said this is why the hearing is about why sanctions should not be entered for the reasons stated in the show cause order. So everything you were put on notice of today explicitly said the brief.
Understood, Your Honor. I mistook that. I thought the court was upset with me for not directly responding to the June 18th order. Let me see. All I can offer the court is this, that the case law that we cite goes to the arguments that were made, and albeit they were not made in the argument section, they were made in an earlier section, but they go to the heart of those arguments that I referenced earlier. Let me see here. On page.
Is there any part of your argument section, Mr. Ramstrong, that you can point to and say this made an argument?
No. The argument section recites certain case law.
So do you agree your argument section included no argument of any kind?
Yes, I mean, except for page 17 where we give a summary of the argument.
Counsel, in your response to the show cause order, and it's not in your personal response, it was in the one filed on behalf of your client. You argue that sanctions would be inappropriate because you have a valid argument for the extension of the law, and in such a case, sanctions under 57-105 would be inappropriate. Is there somewhere in this brief where you ask us to extend the state of the law to incorporate your facts?
I'm not understanding the question.
Is there any argument in your initial brief for the extension of the application of the legal authority that would presently govern this lawsuit?
I mean, we cite the areas of the law that we believe support why the court should have what was incorrect in denying our motion to admit the third amended complaint, and why they were incorrect as to dismissing the action with prejudice. I mean, I believe those recitations stand for that proposition. Let me see.
Which part of the argument section did you explain why the trial court erred in dismissing the second amendment complaint or denying leave to file the third amendment complaint?
That would have been in the earlier section where we recite kind of the history of the case.
Okay, so you had a statement of case and facts that says the trial court dismissed it, and then you have an argument section that says nothing or doesn't contain any argument.
Yeah, I think
so
we kind of went about. Apologies, sorry.
Which part of the brief would you say explained or provided some type of argument as to why the trial court erred?
I would say the section that comes before the summary of the argument. We kind of put our arguments within that area and in response to the facts as we put them forth. We kind of take a position at that stage.
Counsel, is it your understanding of the Florida Rules of Appellate Procedure that you are permitted to make argument in the factual background section of your initial brief?
No, Your Honor, but I didn't think it would be inappropriate to do so. I mean, this was not
to put argument in the facts section.
Well, I mean, we did put the arguments there as we set forth the facts. We stated our position on those facts, and I believe that what follows supports those positions.
Counsel, do you agree that the trial court's order comes to us with a presumption of correctness?
Yes, Your Honor, I never thought about it, but yes.
And so I share what's, I think, clearly been articulated by my colleagues, and what we were struggling with is if we have a trial court renders an order and it carries with it a presumption of correctness. And then it comes up to us, and we have a brief that contains no argument. We have that brief based on things that are outside the record, contrary to the rules. And we also have an absence of a transcript. When the order that is presumably correct specifically says, for the reasons stated on the record,
Understood,
it was
Your Honor.
dismissed. So
If I may-
explain to me how that, all of that taken together, would be a good faith appeal.
In this case, Your Honor, the lower tribunal did not articulate reasons. We say that within the recitation of facts section. It did not give reasons or
His
findings.
order says that, but his order says that he stated it at the hearing. Judge Falcone wrote, one moment, please. Judge Falcone wrote, for the reasons stated on the record, LSQ's motion to dismiss is granted. Foreman's second amended complaint is dismissed as to LSQ with prejudice. For the reasons stated on the record, Foreman's motion for leave to amend is denied as amendment would be futile.
But Your Honor, in this case, there was no transcript or anything of that nature in this case. We have no record of what was stated at that hearing.
Counsel, it's your burden to demonstrate that the trial court erred in dismissing the complaint. Is that correct?
Yes.
Okay, so I think this goes back to Judge White's question, which I interrupted when you stated that the trial judge did something to the effect of he did not put something on the record, or he did not state it at the hearing. Let's call it stated at the hearing. There doesn't seem to be a record.
Well, my only point was that the order did not include the findings from that hearing. Or did not include the reasons.
So you're saying he did state it at the hearing orally, but it did not put it in the written order?
I mean, as I sit here before you today, I can't even recall if he did or not. You know, we felt the reason we filed the appeal is we felt we weren't given a good reason as to why it was dismissed.
Is there something under Florida law that requires the trial court in this sort of action, given the claims that were raised in this particular case, to make affirmative findings when dismissing the case with prejudice?
I was under the impression that the trial court has that responsibility when making a final judgment.
Based on what authority were you under that impression?
As I sit here before you, I don't know it.
Wouldn't that have been something important to determine before you filed an appeal?
Respectfully, I didn't know that this was going to be an issue in this type of regard. We filed.
You just said that you thought the trial court erred by not putting written findings in an order, and then I asked you from where, and you said, "I don't know." So if you're filing an appeal thinking that the trial court erred based on not including written findings in an order, isn't that something you should look into and determine you're right about, or have some legal basis to think before filing an appeal and having us spend resources on it, the opposing party spend resources on it, that could have been spent on a meritorious appeal?
Your Honor, I'm not trying to be difficult. I don't think I'm understanding the question.
You told me, counsel, that the trial court erred by not putting written findings in the order.
Yes.
Correct?
Correct.
Okay, then I asked you why you thought that, like from what authority, and you said, "I don't know of any." And so what I'm saying is, if you're going to file an appeal thinking that something was an error, shouldn't you have some reason or legal authority to think it was an error before you file the appeal?
Well, I believe we do address that on page 5 of in the statement of facts. We state that the lower trial tribunal did not articulate any specific deficiencies
Counsel, that's not the question I asked you. I'm not asking whether you said he didn't articulate reasons. I'm saying whether you had any legal authority to show that he needed to articulate reasons.
No, but respectfully, that's not an issue that we raised in this complaint. I mean, or in this appeal.
Well, you just told me that your argument is within your statement of facts. That's what's in your statement of facts. And then you tell me that you just told me a few minutes ago, the three of us, that the trial court, you believe, erred by not including written findings in his order. Do you see why the absence of any argument in your argument section would make it hard for us to figure out what your argument is?
I'm starting to see
Yeah.
the struggle you guys have had with this.
Counsel, I'm going to get back to a question I asked before that wasn't clear. In your response to the show cause order, my understanding from reviewing the response, and it's the latest response, is that 57105 sanctions would be inappropriate in this case because, quote, the appellant believed it was asserting a good faith argument for the extension of existing law based on such cases, and then you quote cases. So is there somewhere in this brief, and maybe for some reason it would be in this fact section, but is there somewhere in this brief where you could tell me that there is a good faith argument made for the extension of existing law?
Yes, within the argument section, which you guys say is a recitation of law. Let me pull it up.
Counsel, if you think there's some part of your argument section that is not just copying and pasting various, items of law, please point it out to us, because we're not characterizing it that way. That's in fact what it is. That's not our interpretation. That's exactly what it is. There's not a word of argument in the argument section. There is just copying and pasting from various rules and cases with no explanation of any kind how any of those authorities apply to this case or demonstrate that the trial court committed error under the facts of this case. If you said, well, that's how we characterize it. If we're mischaracterizing it or characterizing it incorrectly, feel free to point us to the section of the argument set, the page of the argument section that you think does contain argument.
I'm looking right now. I mean, I just pulled it up, page 23. Refusal to allow an amendment is abuse of the trial court's discretion unless it clearly appears that allowing such amendment will prejudice the opposing party. The privilege to amend has been abused, or amendment will be futile.
Okay, so copying and pasting authority, we got that.
Yes,
part
but
of that-
again, that relates to earlier arguments made in the brief. Not necessarily within that quote unquote argument section, but relates back to other sections where we take a position that we should have been allowed to amend.
But there's nowhere, it strikes me that there's nowhere in the brief where it says why you should get an opportunity to amend. For example, Judge Falcone erred in finding X, Y, and Z, and then walking through the factors that lean toward permitting a party to amend. There's no moment where you say why he erred. Maybe he got futility wrong. It just strikes me that there is nothing, at least at a minimum, not in the argument section, that tells us why he erred. Where is the demonstration of error, which it's your burden to do? Your burden to satisfy, rather.
I mean, he gave no reason as to why amendment should be disallowed in the case.
Counsel, I get it. There's a place in your statement of facts where you say he didn't give a reason. Okay.
Mhm.
But in order for that to constitute an argument, we would need some kind of match between a statement of facts and law, and then applying that law to facts, right? That's how arguments work. So for instance, there's nothing in your argument section giving us any law saying he needed to give facts, and then saying hey, look, in my statement of facts section, I pointed out that he didn't give those, and that's what the order says. It's missing those facts. Here's the law that says he was required to give those findings or reasons. Therefore, he erred. Do you see how that kind of thing is wholly missing?
Absolutely. And yes, we don't have that cadence of an argument, but I believe those pieces are there. It just
Is there a piece where you give us some authority for the proposition that he needed to state findings in his written order?
let me pull back up number 20, page 23. I thought I saw something there.
Counsel, there's not, because he doesn't. That's not a thing.
Well, we cite
Trial judges ruling on a motion to dismiss are not required to make written findings in their order. You won't find that because it doesn't exist in the state of Florida. That's not a thing we do here.
Well, I understand, but there's a case we cite to Carrila v. Jean D. and Catherine T. MacArthur. Ordinarily, dismissal with prejudice should not be ordered without giving the plaintiff an opportunity to amend defective pleading unless it's apparent that the pleading cannot be amended to state a cause of action. No such finding was made that this was.
He found it was futile, counsel. He made an express finding of futility, Judge Falcone did, in his written order dismissing the operative pleading.
But that's exactly what we're arguing against. We're arguing that this is not futile. Maybe he just misunderstood our cause of action or what we were trying to do.
But how do
Judge
we
White, do you want to say something?
how do we know he misunderstood it when he referenced, and Judge Mize is correct, he doesn't have to make written findings in the order. He says, which is presumably correct because it's in his written order, he says, I gave my reasons. You're not suggesting that in the absence of a transcript that you satisfy your burden just by saying that a judge actually did not state reasons on the record?
Not at all. No, not at all. We're just saying our only position is that I mean, yes, he made the finding that it was deficient, but our position is that it's not, and therefore that's why we were trying to amend the complaint. But we believe the amended complaint we put before the court satisfied those deficiencies.
Counsel, let me ask you about, I'm a little puzzled about your filing, this amended response that Judge Brownlee referred to that you filed on the 25th of this month, amending your prior response. And it starts out, it says appellant, Foreman Electric Services, and undersigned counsel. That was one of your amendments because, as had been pointed out, it didn't appear to us that you would have filed it on your own behalf in addition to your client. So you corrected that. And then, but on the last page, however, your signature line, it says underneath your signature block, attorney for appellant, contractor litigation financing LLC.
I probably copy pasted that signature block. Apologies.
Okay, so that's just a typographical error, or does contractor litigation have some interest in this case?
None at all.
Okay.
Counsel, did you proofread the brief before you filed it?
This brief, yes.
Okay. Because there's a lot of things in here that are like, even in the statement of facts, either obvious misstatements or otherwise mistaken. You tell us there's a U.S. District Court for the Western District of Florida. That obviously doesn't exist. You make a lot of statements about like at all material times there too, but then you make a statement that kind of by its nature cannot be done at all material times there too, like something that happened on a specific date. Like you said, like at all material times there too, the parties entered into a contract, or at all material times there too, a particular pleading was filed. Things that by their nature don't happen at all material times there too, that happen at a specific point. So that kind of made it hard for us to even follow the statement of facts because it just large parts of it were nonsensical.
I see. The reason we put that statement in at all material times, we were trying to point the court to the pertinent facts that upon which we're basing our arguments.
But what I'm saying is when you say at all material times there too, for numerous statements, and it wasn't just once or twice, it was a bunch of statements. And then what follows is something that by its nature doesn't happen at all material times there too, right? So like If you say at all material times thereto, someone had a duty, right? That's the kind of thing that can happen over a period of time. And it can make sense to say that duty existed at all material times thereto. When you say at all material times thereto, they filed an answer, or at all material times thereto, you know, someone entered into a contract. Those are things that by their nature happen on a particular date. They don't happen at all material times thereto by their very nature. And you kind of did that throughout the brief, throughout the statement of facts section.
I see. I use that to state that at all times, that are material to his action, Foreman did enter into a contract. I'm looking at right now, I'm looking where I see that on page 8. For example, where you say at all times material here too, Foreman submitted the 5th invoice to Halloran for materials and labor.
Well, that's what I'm saying. Can you submit an invoice at all material times throughout a dispute, or do you submit an invoice at a particular time?
Well, at a particular time, but in reference to this action, what we're trying to say here, that we're trying to say that this is, this is a pertinent fact, and maybe there's a better way I should have said that, but that's what we're trying to say by way of that introductory remark.
Counsel, if we were to conclude that this brief was frivolous or in bad faith, what do you believe the appropriate sanction would be?
I mean, I would ask this court not to monetarily penalize us. I don't know what other sanctions or options are available. This is the first time I find myself in a situation like this.
Counsel, after hearing from us, do you think the brief had any merit? Not your claims, but the brief.
I believe the brief has merit, but I think it could have been written much better. And albeit I didn't write this necessarily, it was my responsibility and I oversaw it and I filed it. With that said,
who did write it?
My assistant. He prepared it. I looked it over. I granted it didn't follow the standards of our argument standards, but I thought it made sense.
Is your assistant a lawyer?
He was a lawyer at one point in time.
Okay. Well, is he a disbarred lawyer?
No, not at all. He retired lawyer.
Counsel, I hear you say that you thought that the brief made sense. Did it, I guess at that time, were you aware that it did not comply with the Florida Rules of Appellate Procedure, either with regard to the appendix, the record, the factual background statement, or the argument section?
With regard to those procedural components, probably not. In all candidness, probably not. As to the argument, I was confident that our argument was meritorious, but procedurally, we were feeling our way around correcting some of those items as we had to make amendments.
I don't understand that point. You mean with regard to the amended initial brief?
Yes, the court directed us, advised us that we filed something incorrect. I can't rightly remember at this point in time, but
it was the initial brief.
Yes, and we went back and we had to do something to fix it.
Why was the amended initial brief filed so far out of time after our order?
Your Honor, to be honest with you, we've just been having, and it's not just with this court, we've been having trouble getting these notifications.
You don't get them via email?
It has not been coming to us via email. We've been getting them via mail. Some of them come in the mail, and I'd have my assistants, pull up, run through our emails or spam, and we can't find those initial because they don't come through the normal channels. They come through something else, something like in the Sixth Circuit, especially some kind of mail.
What do you mean by the Sixth Circuit? You mean the trial court?
No, the Sixth District. I apologize. The Sixth District. They especially come in a different manner than we're used to. I forget what it's called, something case mail or something like that. The orders come through, and they have been going through our spam folder for a period of time. These case mails, and ultimately they haven't been coming through the e-filing portal, which is typically how we get orders and other. And not saying you guys are wrong or we're right or anything like that, that we overlooked that. We didn't realize that these notifications were coming through something called case mail. rather than through the e-filing portal.
Do you think that's something you should bring to our attention?
I believe we did. We notified whoever when we realized we were filing late, we spoke to the clerk or whomever, and we were instructed to simply file at that time.
I think maybe what you're referencing is the fact that trial courts, that you get served with items in trial courts in a different manner than you do with appellate courts.
That's true, but even in the third district, like an order will come through the e-filing portal, not necessarily through this email platform that is coming through on the 6th District Court of Appeals.
Counsel, is this the first time you've ever practiced before the 6th District Court of Appeal?
Yes, yes. Not my first time in Orange County trial court, but yes, before the 6th District the first time.
Was there any moment where you tell us, let's see, the order requiring an amended initial brief states that the appendix to the initial brief does not comply with Florida Rule of Appellate Procedure 9.220C. It wasn't bookmarked, and to file a corrected appendix within 10 days. And well after 10 days, that gets filed. So did you ever tell us the reason that you were filing out of time, or ask us to accept something as timely filed, or anything to that effect?
No, I did not, Your Honor. I did not file anything requesting that be taken in or anything of that nature at that time.
All right, and counsel, when I look at the appendix that was filed, well, let me make sure that I'm on the right one here. Yeah. Did you do an appendix to the amended? Yeah, you just call it. You don't call it amended, but you'd call it the
Appendix.
appendix. So it has the same name as the original one. Okay, so in it you cite, or you include rather, the subcontract agreement with Haleron Power LLC. Is that included in the record on appeal?
I believe it is, Your Honor. Let me double check.
We're going to go through all 5 items, so you might want to pull up that
let me
record,
pull the
because
record on
the
appeal.
appendix is, if you're going to do an appendix to the initial brief, certainly and bring our attention to documents, those documents in accordance with the rules have to be included in the record on appeal, or else it would not be proper for us to view it.
Understood. We're just looking at the index to the record on appeal right now. Notice of appeal. We see that the motion to amend statement of claims third is part of the index. If that's the case, I would represent that the third amended complaint with the attachments are before the record.
Sorry, you mean the subcontract agreement is included in the record as an exhibit to that document?
To the third, yes.
Okay, what about the Texas case?
I believe that's also in the third amended complaint. I'm not sure, though. And forgive me, I'm having trouble pulling up my copy of the record. All I have is the index for the moment. But we make this is the third amended complaint is where we make those arguments to try to address the deficiencies that the appellee brought up in the lower tribunal in the lower court. So that's where we try to make our arguments, and it's honestly, it's by virtue of that, the existence of that document, why we believe that the case was incorrectly denied with prejudice.
Okay, so with regard to all of the documents included in the appendix, the notice of removal, the second amended complaint, obviously that would be included, I would think, in the record, and then the settlement agreement and release, all of those are included in the record on appeal?
As I see here, all I have is the index, but I believe so, yes.
Counsel, the Texas case, without going through every single page, is 63 pages of documents in your appendix. The third amended complaint in the record with all attachments is only 57 pages. So it's not, without going through each page, it's not possible all those documents are attached to the third amended complaint.
Okay. No, I see what you're saying. I mean, I know for a fact we do mention it within the third.
So the question Judge Brownlee asked is, are the documents in your appendix Are all of them in the record on appeal, or are there some that are not?
I mean, I'll have to say I don't know because
Was that something you were required to verify before filing the appendix?
Yes.
Okay.
But whether it's in there or not, at least as to their answering affirmative defenses, LSQs, we do cite to that case and reference that case expressly.
Counsel, is it appropriate under the rules of appellate procedure for you to give us documents outside the record?
No.
Okay. All right. Judge White, Judge Mize, do you have any further questions for appellant's counsel?
No.
Mr. Ramsaran, sorry, Judge White, excuse me. Mr. Ramsaran, is there anything, any final point, anything that you want to tell us in an effort to avoid sanctions in this case, either under the rule or under the provision of the statute that we cited and given what you've heard today?
I mean, I can say at least pursuant to 57105, I believe that we've cited some cases that bear similarities to our own. I would argue that the cases that we cite to were actually weaker than our own, because our case actually is supported by facts and evidence. Particularity comes to mind is Coretta trucking case. I have a lot of documents open right now on my laptop. In that case, Coretta trucking. Both cases involved decisions where a lower tribunal dismissed the party's actions with prejudice. And the Coretta trucking matter, the appellee disparaged the appellant's efforts to assert a claim for breach of contract as a third-party beneficiary and argued that the appellant was once more asserting its claims and amended its complaint following prior dismissal. In this case, LSQ is arguing that the invoice purchase agreement doesn't create a contractual duty to discharge senior liens in the case. I would.
It says authorized, right?
I'm sorry.
Go ahead, counsel.
I'm sorry. What were you saying?
I thought you were making the argument that they were required to pay off the liens and the contract.
Well, they were arguing the contrary.
Excuse me, counsel. Excuse me, counsel.
Sorry.
The contract specifically says the word authorized rather than obligated, correct?
Yes, Your Honor, of course. But we believe that by virtue of the invoice purchase agreement, their response and their answer and affirmative defenses, and our subcontract agreement taken as a whole, it could construe a situation where we have a third party beneficiary relationship under a contract, by virtue of the fact that, and I think I break this down a little better here, viewing LSQ's third affirmative defense in conjunction with paragraph 11 of the invoice purchase agreement, appellant contended and continues to contend, and the third amended complaint that there's sufficient basis to assert a cause of action for breach of contract against a third-party beneficiary. Stated differently, LSQ made prior representations that LSQ and Haleron came to a meeting of the minds at the time of forming the invoice purchase agreement, whereby LSQ agreed at the behest of Haleron to pay all monies owed to certain contractors, including former electric services. And if that was proven true, it may be sufficient to demonstrate the language contained in paragraph 11 of the invoice purchase agreement was, and I won't use the word at all times, but that it was intended for the primary benefit of former electric services.
But counsel, if I could ask you, sort of circling back, do you understand that we could find, just for the sake of argument, we could find that maybe you made a non-frivolous argument before the trial court, but that brings us back here with the rules and the requirements of an actual argument in the brief, the requirement that prohibits you from providing us with documents outside the record. And your failure to provide a transcript, which would perhaps show us, or you're aware that the rule also allows you, in the absence of a actual transcript, to work with appellee's counsel to reconstruct the record before the trial court. Are you aware of that under the appellate rules?
No, I am now. Thank you, Your Honor.
Okay. And so tell me how your cases, which of your cases, and I looked at all of them, I don't recall seeing a case that dealt with an issue of whether an appeal is frivolous. Which cases do you believe would support your request that we not sanction you for a frivolous appeal?
Understood. I don't believe I cited to anything of that nature, Your Honor, in my response.
Would you like to make any sort of argument or response as to why we shouldn't sanction you for a frivolous appeal?
Yes, Your Honor. I mean, I would argue that, at least as far as the amended brief, and granted, you know, I've been fully briefed on the deficiencies and the problems with that document as of now, but I would argue that, although out of place, the conclusions, the arguments, the support, legal precedent, I believe all the components are there to make those proper arguments. We give a recitation of the facts, then we provide our conclusions, or our position rather, on those following that recitation of the facts. And then what follows from there is support that's intended to support our position or argument. And I agree that it's not necessarily the way I would have drafted it or preferred it to be drafted, but at the time I looked at it and the time I read it, I did not acknowledge or appreciate, well, I guess that this type of issue could ensue, or that it could be construed as frivolous.
All right, thank you, counsel.
Judge
Thank you.
Mize, anything further? No. Okay. All right, Mr. Fowler, I know that you've been present with us today. We set this for a show cause hearing, sua sponte. There was no request for this. I understand that your client did a separate request for sanctions under 57105 that solely requested sanctions against appellant rather than appellant's counsel. So at this point, I guess, to put it in a not so eloquent way, I'm wondering if you have a dog in this fight. We're not trying to ignore you, but we're here on our order today. So, you know, unless there's something pressing that you think needs to be brought to our attention.
There's not, Your Honor. Thank you.
Okay, thank you, Mr. Fowler. All right. Mr. Ramsaran, anything further, sir, before we adjourn today?
Nothing that comes to mind, Your Honor.
Okay. All right. All right. Thank you for your presentation. We will issue an order on today's hearing. As of now, we're adjourned.
Thank you.
Much more productive I'd be if there wasn't constantly an animal that needed attention. I'm muted. I'm not muted, am I? There's that green. Okay, I'm good. All right. So let me tell you what the court ordered, their opinion, and then I will tell you some more about the attorney and his paralegal. Why are you giving me dirty looks? You climbed up here. This is a fat cat. I'm just saying. She's not fluffy. She is fat. So the hearing happened on October 28th, 2024, and 2 days later, the court got this out. I think I made a comment the other day about it taking forever for the appellate courts to get their decisions out, referring to a Tennessee court, and this one, wham, bam, thank you, ma'am. So the first paragraph is just background information. The important one is this one. Attorney Ramsaran appeared at the show cause hearing on October 28th, 2024. It answered the court's questions and responded to the order to show cause. Despite counsel's statements at the hearing that he has reviewed the Florida Rules of Appellate Procedure and participated in more than 10, but fewer than 20 appeals, counsel's answers to the court's questions consistently revealed an unfamiliarity with the rules of procedure and appellate practice in general. In particular, Attorney Ramsaran demonstrated a lack of knowledge of the briefing requirements. the record on appeal and the burden his client faced as an appellant. The court finds this particularly concerning given the fact that Attorney Ramsaran appears to regularly practice before Florida's District Court of Appeals. Consequently, within 30 days of the date of this order, Attorney Jerome Ramsaran shall complete 2 continuing legal education classes available immediately on the Florida Bar's website. The first is a basic appellate procedure, and the second is practicing before Florida's 6th District Court of Appeal. Differences and similarities. Interesting. Attorney Ramsaran shall file proof of completion of these 2 classes on or before December 1st, 2024. Next, having carefully considered counsel's statements at the show cause hearing and having reviewed the responses to the show cause order as well as other documents filed in the case, the court finds sanctions in the form of attorney's fees are appropriate. Rule 9.410A provides that the court may impose sanctions for any violation of these rules or for filing of any proceeding, motion, brief, or other document that is frivolous. Similarly, provides the sanctions when the application of then existing law to material facts does not support a claim or defense, and a finding under this section is tantamount to a conclusion that the claim was frivolous when filed or later becomes frivolous. See Aspen Air Conditioning v. Safeco. Frivolous, for our purposes, means appeal is completely without merit in law and cannot be supported by a reasonable argument for an extension, modification, or reversal of existing law. And that's Enri, ATH. And also Aspen Air. Noting Florida law contains guidelines for determining when an action is frivolous, including where a case is found to be completely without merit in law and cannot be supported by a reasonable argument for an extension. Yeah, we just said that. An appeal which lacks a factual basis or well-grounded legal argument will be considered devoid of merit. That also cites Enri, ATH. This appeal was frivolous. Oof. Not only are any arguments that can be gleaned from this brief not supported by the application of then existing law to the material facts, but the amended initial brief failed to comply with the Florida Rules of Appellate Procedure. And that would be Rule 9.410A. Indeed, as appellee noted in its motion for sanctions, the argument section of Foreman's brief contains only citations to general legal principles, making it nearly impossible for appellee to even craft a coherent response. We agree. The argument section contains essentially no argument and certainly did not contain an argument with regard to each issue, as required by Florida Rule of Appellate Procedure 9.210B5. And although appellant's response to the show cause order asserts that at the time of filing the initial and amended briefs, appellant believed it was asserting a good faith argument for the extension of existing law, no argument for extension of existing law appears in the appellant's amended initial brief. Importantly, it was counsel for appellant, rather than appellant itself, who was responsible for preparing an initial brief that complied with the Florida Rules of Appellate Procedure, and who should have known appellant's claims were not supported by the application of then existing law to the material facts. In fact, when sanctions are deemed appropriate under 571051B, monetary sanctions may not be awarded against a represented party like appellant. 57103C, Florida statute disallowing monetary sanctions against a represented party where sanctions are awarded under section 571051B. In light of the foregoing, we ordered Jerome Ramsaran, Esquire, to pay appellee the reasonable attorney's fees incurred by appellee in defending this appeal. We remand this case to the lower court to determine the reasonable amount of such fees to be paid in full by Attorney Ramsaran. Wow. So the attorney is required to take those 2 courses and personally pay the fees of the opposing party for anything that happened as part of this case. Ouch. Unfortunately, this isn't the first time Mr. Ramsaran has had a little bit of an issue with the Florida Bar. several years ago in 2020, there was a complaint filed against him pursuant to Rule 37.4. He actually admitted to minor misconduct in 2020. Okay, 2022 is when it was resolved. And what happened was Mr. Pawlowski of Florida Lifestyle Mortgage, he filed the grievance after receiving a demand letter from Mr. Ramsaran, who advised he was counsel for Legal Justice Advocates LLP. And the demand letter alleged that a tester from Victims Awareness Inc. attempted to navigate their website, the Florida Lifestyle Mortgage's website, using a screen reading software. This tester was allegedly trained to test for online accessibility for blind and or visually disabled individuals. The demand letter declared that the website was in violation of the Federal Fair Housing Act and the Florida Fair Housing Act and demanded action be taken to make the websites readily accessible to and usable by blind and visually impaired individuals. The letter stated that because the individual's non-compliance with FHA regulations, Victims Awareness, Inc. had incurred damages, attorney's fees, and costs related to its compliance and enforcement efforts. Like, what? Sorry. The demand letter further stated that they reserved the right to seek judicial enforcement. Victims Awareness attached a blank pre-drafted complaint that was to be filed in federal court with the letter. Mr. Ramsaran was unable to provide the bar with a signed and dated retainer agreement reflecting that Legal Justice Advocates LLP, which I believe was his company, represented Victims Awareness Inc. The only agreement provided to the Florida Bar was an unsigned template of a retainer agreement. The bar was unable to locate a working website or telephone number for Victims Awareness Inc., and efforts to contact the 3 members of Victims Awareness Inc.'s board of directors revealed that one was deceased, a second could not be located, and a third individual with the same name denied any knowledge of Victims Awareness Inc. As a result of the bar's inability to verify any professional relationship between Mr. Ramsaran and the Victims Awareness Inc., the grievance committee accepted the respondent's tender of an admission of minor misconduct and finds that the following rules regulating the Florida Bar have been violated: 4.3-1, meritorious claims or contentions and misconduct. The committee believes that the following comment on mitigating, aggravating, and evidentiary matters will be helpful in considering acceptance of the report. He's never been disciplined before, and he has ceased performing this type of legal work. And he's going to pay the cost. That's shady. He was just randomly sending out letters, like with no authority to do so, saying, hey, you violated someone's civil rights, not mine because I'm not blind, but somebody's civil rights were violated. And I tried to look up his paralegal, who he said was a former attorney, because I was just curious what makes someone not be an attorney anymore, because it doesn't take a ton to stay an attorney when you consider the benefits, but then to work as a paralegal instead of an attorney, I was like, what? Something's not right there. Something doesn't sound right. I may hate on Florida a lot, but it is really hard to beat the level of access that they provide, the open documents, the Sunshine Law. So S. Tracy Long, who is the paralegal for Mr. Ramsaran, was an attorney. He was admitted to the Florida Bar in 1990. And his first bout of trouble came in 2014, it looks like. Well, that was the first documented one that I'm seeing right now. And he was suspended by the bar for 1 year and consolidated quite a few cases that were pending against Mr. Long related to what the Palm Beach Post headline said was attorneys suspended for multiple foreclosure-related offenses. In addition to what we already talked about, He was paying the non-attorney a contract that gave him 12% of the legal fee. Yeah, you can't do that. He didn't pay a mediator after he was dissatisfied with the service. He took on a client to defend their foreclosure action, charged them $2,500, and failed to communicate the actual chances of success because there was a statute of limitations preventing him from proceeding. They ultimately lost their home. He failed to properly represent a church in a case against the city of Sunrise in which he accepted $2,500. The lawsuit was filed in federal court where Long was no longer licensed. He was hired to defend a foreclosure action in New Jersey where he was not licensed to practice law. He hired a New Jersey attorney to handle the case, but the attorney did not work on the file, and the homeowners paid $6,500, but a final judgment was entered against them. It looks like about 6 months later, 8 months later, maybe, while he was still suspended, the bar inquired about something else that was going on, and he failed to respond to them. So there was a show cause requested, and he did not respond in a timely fashion. So there was another reprimand on his file in 2015. When 2018 rolled around, it appears Mr. Long still had not petitioned. I mean, I'm assuming it's a Mr. He said Mr., right? Still had not petitioned to, be reinstated to the bar. However, there was another complaint against him that occurred prior to his suspension. In this one, it appears that he had agreed to represent both a husband and a wife in a foreclosure action. He proceeded with it, but never communicated with the wife, who was unaware of both the foreclosure case and his representation. So in 2018, he issued a conditional guilty plea for a consent judgment that was filed with the Supreme Court of Florida. Even though he hadn't been reinstated, his penalty was a public reprimand to be served by publication and pay the cost of the Florida bar in investigating the matter. In 2019, Mr. Long petitioned the bar to reinstate his membership in good standing in the Florida bar. He wanted his license back. He wanted to practice again. He was ready to go. He learned his lesson. Let's do this thing. He said the primary conduct, offense, and misconduct involves the business structure of the foreclosure defense practice. The petitioner attempted to set up a practice whereby a separate company would be responsible for performing legal assistant, paralegal services, administrative services, customer services, marketing and promotional services, billing services, collection services for a billed fee. So everything? The Florida bar found the business structure to be improper due to lack of management and control by the petitioner, and the fee structure to the separate company was fee sharing or splitting. The date of the suspension for the period was 1 year, commenced on December 23rd, 2014 by a settlement agreement between the petitioner and the Florida bar. I apologize for jumping around, but there's a lot of personal information in here. Mr. Long indicated that during the time that he had not requested reinstatement, that he was working as a legal consultant and also doing legal research and other things freelance for several people who knew him and for a couple websites. His statement of facts claimed to justify his reinstatement. The primary fact that justifies reinstatement is that I have served 5 times the amount of the original suspension of 1 year. Part of the extended suspension was intentional on my part. The other part was based upon my circumstances after the suspension took place. I will address the intentionality element first. I was never the same after my statement before the grievance committee prior to the suspension. The statement made me question everything about myself. Prior to the statement, I believed I was a good person with pure intentions. Part of the reasoning behind the mechanics of the foreclosure practice that I set up was to get homeowners that were undergoing foreclosure away from the people and entities that would ultimately do nothing but take their money and take advantage of them. That's what he's charged with. Based upon my interaction with the bank's attorney, I understood that the only way to win a foreclosure was to modify the mortgage so the homeowners could stay in their home. My firm was highly successful, much more than most, in getting homeowners modified and keeping them in their home. Unfortunately, that never factored into the statement before the grievance committee and ultimately my suspension. The point is that the members of the grievance committee questioned every decision I made and even my character in making these decisions I made, no matter how well intentioned. The questioning made by these members of the grievance committee made me question whether I was a good person or not. Many of my friends and former colleagues have reviewed my consent judgments that I agreed to and have commented that they were not that serious. I have questioned why I have not applied for reinstatement until now. The charges and consent judgments were not minimal or inconsequential to me. I did not want to return to the practice of law until I could determine for myself the truth of what happened. That is where the circumstances of what happened to me following the suspension come into play. Naturally, as a result of the suspension, I was not able to earn the same level of income I was before. This led directly to additional problems with my marriage and foreclosure of our home due to inability to pay the mortgage. The result was a divorce that just became final on December of 2019, the loss of our home. My family has been split apart. The point I am trying to illustrate here is that I experience firsthand the same consequences as the clients I represented in foreclosure. I came to realize that the minimal money that I was charging for my services in foreclosure and modification, although minimal to me, made all the difference to them in holding their family together. For whatever part I may have played in any of my clients experiencing the same thing I have experienced, I am truly sorry and remorseful. My only solace is that I was able to help substantially more clients than I have harmed. Well, thank God for that. I have learned firsthand the consequences of my actions, returned several-fold, that's a new one, for the bars and specifically Michael, I'm not sure who that is, I think it might be a judge, in helping me see the truth. I am sincerely thankful. The other truth I obtained by working as freelance paralegal doing litigation support for a number of attorneys. The primary focus was almost every attorney I encountered was making money and what a case and yield for them. Naturally, that element is going to factor into every representation. What I gained from providing freelance services is that the temptation to bend the rules and take advantage of the client in order to maximize your own income exists at every turn. What I did not realize prior to my suspension is that an attorney is the last line of defense against a client being taken advantage of, even if that threat is yourself. It is relatively easy for an attorney to take advantage of a client rather than resist temptation when nobody is looking. Again, by taking the path ahead of me after the suspension took effect, I was able to realize the essential truth of an attorney's duty, and I can't get past that. No, most people don't see opportunity to screw people over. That's not the first thing you see. Again, by taking the path ahead of me after the suspension took effect, I was able to realize the essential truth of an attorney's duty, and I had not truly appreciated before. As an attorney, I am the guardian at the gate. How did he miss out on all those ethics classes? I believe these truths will aid me in my effort to seek redemption. My career goal, should the bar agree to reinstate me, is to focus my practice on litigation support and appeals. In other words, I would work for attorneys rather than directly for clients. It is in this manner that I would seek to minimize and even eliminate any temptations that I referenced above while maximizing my ability to watch over the welfare of clients. Oh, Lord. In the last week, I heard somebody much wiser than me say, if you have nothing, just do what you can, and God will do what you cannot. I can go no further with my redemption without a second chance. I have many debts to pay in every aspect of matters, so I humbly request a second chance to practice as an attorney. I want to restore my name. Yeah. You probably shouldn't be working in that field. I don't think you're rehabilitated. I'm just saying. They brought in a referee to review everything that has gone on in this case and determine if Mr. Long was acceptable to be reinstated to the Florida bar. As time went on, 6 months or so, Mr. Long submitted a withdrawal of his petition for reinstatement. And the referee reported that he was unable to offer an opinion due to the notice of withdrawal being filed filed. Interesting. So, when a judge asks you if it was a disbarred lawyer, technically no, he wasn't disbarred. He was suspended and never reinstated. I'm kind of thinking those are similar enough that you should articulate that to the judge, but you know, I mean, semantics. Technically, he wasn't disbarred. Wow. Welcome to Florida. And there you have it, folks. But wait, there's more. We're just gonna record this as we go. If it's been 10 years since you've been admitted to practice in the Florida Bar Association, if it's been 10 years since you've been admitted to practice, would you still have a LinkedIn up and a Facebook and a bunch of other websites? I mean, 10 years? Like, bankruptcies don't even stay on your record that long. Feel something shady going on here. All right, my friends. I have a feeling I'm not done digging on this one. We'll see. Have a great afternoon. I will see you soon. Thank you for being awesome and for all your support. I would love it if you would hit that like button, hit the subscribe button, because next time you're not going to get this. You're going to get something totally different. Who knows?